thanks so much for joining us today. It's a little bit of sunshine here today. Got to love that. Makes you feel a little bit optimistic about the day. I hope things are going well in all of your stores and all of your endeavors. My name is Bruce Newstead with the Minnesota Retailers Association. It's great to have you on today's webinar on an important topic. We'll be talking about website accessibility. And we've got two great experts with us today. We've got Steve Helland with Fredrickson and Byron. He's the founder of the firm's Accessibility Technology Defense Group. And we've got Michele Landis. She's co-founder and CRO of Accessibility360, which is now a digital division of Allyant. So it's great to have our experts on. Just from a format perspective today, Steve and Michele are going to give us some great information. They'll present some slides to you. They'll save some time at the end for questions. But we're just so grateful to have you on. I also want to welcome the chair of our board at MINRA, Marissa Kinney with Red Wing Shoe Company. Great to have you on, Marissa. Thanks for joining us today, and thanks for your leadership here at the association. With that, we'll save the introductions to that, and we'll get right to Steve and Michele. So, Steve, you want to get us kicked off today?
Yeah, absolutely. Hello, everybody, and welcome. Let me see if I can now share my screen successfully as we launch into these slides. All right, Bruce, are you let's see here. I need to click this button. Bruce, are you now seeing my screen?
I do see your screen with your preview, your toggles on the left side. I think you said that's the way you wanted to run it. So, yep.
Yep, and that's what it'll be. All right, so welcome, everybody. This is a great topic. I want to begin by saying a couple of things. First, thank you to a bunch of different folks. Thank you to the Minnesota Retailers Association for taking time for this topic, which I think has touched or impacted quite a few organizations. As well, thanks to the Elk River Area Chamber of Commerce. Bruce, thank you for your facilitation of the presentation. What we're talking about here is the evolution of disability law from a physical space to a digital space. And we'll get more into the particulars. I'm Steve Helland. I am a partner at Fredrickson and Byron Law Firm. And I've been working in this space for now around a decade and have represented scores of clients in both negotiations, compliance issues, and resolving lawsuits. And that's me. My other comment is, as much as I've occasionally had my presentation comments quoted back to me in the context of litigation or disputes, the comments I expressed here are only my own and not those of this law firm. And they're for informational purposes only. They may or may not be applicable to any particular case or dispute. And with that, over to Michele to introduce herself.
Hi, good morning, everybody. Very much looking forward to the discussion today. And I do want to just go back and reiterate my place in the field and the market now. As Bruce said in the introduction, I was a co-founder of Accessible360, which was a Minnesota company, actually started here. And I'm really excited to speak to this group because it was actually the collaboration with Steve Helland and others early on that got us started. Accessible360 was sold. The new company that purchased it and a couple of others and put a new brand together is called Allyant. And the team at Accessible360 makes up the digital department of Allyant now, and I've exited from that post-sale. So, but my work in this field began, as I said, with Minnesota retailers, and it's taken me really around the globe into every business vertical, into all sizes of companies. I've had the opportunity to work with several of the companies represented today. I've worked with and collaborated with Steve on clients, as he said previously. But this still is a very litigious business topic for especially retailers. We're looking forward to sharing and discussing more information with you today. So I'm going to go ahead and take over the screen share, and I'll go into presentation mode for you.
Michele, before you do that, can I just share a couple quick slides and then I'll pass it back to you?
Yeah, absolutely.
Great. So first, so are you all seeing my screen now with website accessibility? Bruce, are you seeing my screen, or Michele, are you seeing my slides? Great.
Yes.
Okay.
Yep, looks good.
All right, so we've got the agenda. I'll do real quick, how did we get here, then to Michele for a deeper dive on what is accessibility. I'll talk about the law, some key cases, some risk reduction, then back to Michele for some more practical tips. All right, you should see now the caption from a complaint, which is the first document that actually starts a lawsuit. This was, so this is a real complaint, it's a public document. It was filed last week. And it's a high volume plaintiff named Raymond Malberg. And he is suing Spencer Gifts, right? We've all heard of Spencer's, they're a national retailer. And I don't mean to pick on Spencer Gifts, right? I could have chose any one of 50 other lawsuits that were filed last week in federal court. There were maybe 150 to 200 filed in different state courts around the country, or hundreds more of demand letters that are private, so we don't have a good count on those. Unfortunately, right, this is the way that many businesses encounter this subject matter. For some reasons we'll go into a little bit further, many web developers are not familiar or are latecomers to the topic and techniques of website accessibility. And also the way the space has evolved, plaintiffs don't typically send warning letters or requests saying, I wish you'd fix this or fix that. Really, the first thing that you get is either a lawsuit has actually been filed or it's a demand letter. All the lawsuits and all the demand letters tend to look quite similar. This is a quote from the same lawsuit. It references the lawsuit, the website Spencer's Online, and it says that as a result, because we cannot access the website, that's a violation of the ADA. We'll go into that more further in a bit. This is the slide from the Wall Street Journal. I show this to my business clients that don't believe me or are skeptical. When the Wall Street Journal, though, says, right, there's a surge of lawsuits that tends to be more persuasive and get people's attention. It really impacts all fields and retailers of all sizes, right? Everything from the small single-person shops and stores to national level retailers. And again, here, I don't mean to pick on these businesses whose logos I put up there. I just really do want to show that it is pervasive. And frankly, at this point in the calendar and how long this has been going on, I'll say, you know, all of you are self-selecting into this topic for a reason. Maybe you've been sued, maybe you know another business that has been sued, but these lawsuits and demands are so common that I will say, if you have not been sued or have not received a demand letter, and you are a retailer with a publicly viewable website, I feel like you are actually now in the minority. With that, I'm going to stop sharing. And Michelle, I'm going to pass it back to you to start talking about your view on accessibility.
Okay, great. Thank you. See if we can get that into presentation mode. Okay, great. So what is this topic, accessibility? It comes by a few other names as well. A lot of people call it ADA compliance. They talk about accessible websites. I tend to use the term equitable access, but there's lots of other nomenclature out there around it. It's really a two-sided coin, right? It's about being inclusive. It's about opening up your e-commerce sites to as many potential customers as you can, which is a good thing. And it's also, the flip side is about compliance, right? So you have the carrot and the stick. We've talked about that for years. The carrot part is obviously really what I find in working through tons of different organizations. When you know better, all but one organization in all the time I've been in this work has wanted to do better. So I think that's encouraging. It's also encouraging by the participation of the retailers today. You're looking at what to do, what's new. This is not new, right? As Steve said, if you haven't heard of it, if you haven't tried to take some steps, if you haven't been the recipient of a demand letter or a lawsuit, you're probably in the minority. I'll actually agree with Steve on that one out of the gate. But what I want to broaden your mind to think about is it's not just your website. If you have a mobile app, if you're sending communications and promotions, what you're doing in your social media accounts, this is digital accessibility, not just website accessibility. And it is really at its core the civil right of all human beings to participate in our digital world, right? My work has brought me into HR platforms and the HR practices of companies. And I don't know the last time any of you ever filled out a paper application with a pen and paper, but it's been quite a few decades, I think, that everything's been online. And so really think about this as all your digital practices. Human beings, this is what it's all about, right? Human beings are different. We have different needs. So just as there's been a huge push for diversity and inclusion, don't forget about the people who access digital content differently. And that's what we're here to work on and help you with today. So there was a Gartner study a couple years ago that I'm really interested in watching now, because it's already 2023. And they predicted that the World Health Organization actually will identify online shopping as an addictive disorder by 2024. Now, some of you might be thinking, that would be great if we had that much participation from the general public. But this concept is, they thought and talked about, well, we have to put warnings on retail sites if there's too much shopping, like casinos and that kind of thing. The other thing that they predicted was that by 2023, the number of people with disabilities employed will triple due to artificial intelligence and emerging technologies, which reduce the barriers to access and employment. This is the one that I can't be more excited about. And as I pivot in my career and my advocacy for people with disabilities, we had the opportunity to employ a tremendous amount of people with disabilities because they offered specific skills that could help organizations, right, learn more about this. And so this is the one that I'm actually quite excited about. Also from the Gartner study of a couple years ago, organizations that actively employ people with disabilities experience almost 90% higher retention rates, over 70% increase in employee productivity, and nearly 30% increase in profitability. So this is, I have you for a brief moment in time before we jump on. This is my attempt to warm the audience up and make sure that you understand that diversity of all forms, including people with disabilities, brings more perspectives to your organization. It brings more customers to your bottom line. And the inclusion practices here that we're going to talk about, both in risk mitigation, how to deal with any legal activities, which is going to be Steve's area, and then really what to do with your digital properties, how to get started, how to think about this and what's coming, really falls into the inclusion concept that it broadens your potential. So let's talk about assistive technology. One of the things that Steve wanted me to do when we kick off is, and we've done this before, we've done an actual JAWS demonstration or NVDA. Those are the two most common screen readers. But when we're talking about people with disabilities and accessing technology, they fall into four main categories, the same four that are covered in the Americans with Disabilities Act, of course, and they are vision disabilities, auditory disabilities, physical, and cognitive. Most of the lawsuits brought by the plaintiffs bar across the country here in the United States have blind plaintiffs. Some of them emerging have deaf clients, and that's gaining some speed. But the software or hardware, the actual machines that people with disabilities use to access your e-commerce websites could range from magnification tools like the built-in settings, actually, or some other ones that they can get off the shelf. Screen readers are most common. Again, those are the software that's installed on their own computers that reads the website to them. Speech recognition things like Dragon Speech and those types of things. Refreshable Braille displays, those are a small laptop device that will actually raise and lower the Braille alphabet to those who know that. And you can imagine if you have low vision or blindness and you're relying on a screen reader to read everything to you, it might be nice to take a break and silence that and actually read by yourself if you know Braille. In emerging countries and across the globe, Braille really still is something that's taught. Here in the US, there are pockets where younger blind Americans are not really learning Braille because everything is digital. So interesting things to think about. The last one I want to talk about is mouse alternatives. So instead of using a mouse or a mouse tracker like I do, and I assume the majority of people on the webinar today, think about keyboard only navigation. One challenge that I have for you by the end of the week, get on your own website and purchase something without using your mouse. Let us know how that worked. Let's talk about.
Can I just piggyback on that and just say that is, maybe a preview, right, of self-help things that a person can do. That what Michele just said is a great initial check, right? Because the blind or visually impaired can't see where the cursor is to track with a mouse. And so that is how a lot of blind or visually impaired people use or function with the website is on keyboard only, the arrows and the tab and the return key. And so I think that suggestion to like test your own site to try to make a purchase or create an account or log in, keyboard only is a great idea.
Yeah, and a lot of times we'll demo that right on the screen. I feel like we've done that for a lot of years, and I think that the audience is past, that elementary understanding. But if this is new to you, do what we're talking about. Test your own. You should be able to see where you are as you go through your site. I know a lot of your sites have a lot of these improvements already made in them, but make sure that you can purchase an item without using your mouse, especially when you get into the payment field and you have all of those sections. If there's a mistake, part of the guidelines and part of equitable access and accessibility means that if there was a mistake in the payment part, that the cursor is brought back to the field and it's announced to somebody who's blind and or low vision, for example, what the error was. So that goes a little bit deeper, but just try that challenge. And first of all, really what I wanted to talk about was just, I'm gonna admit, I don't know if anybody else is watching the waiting room, so I'm just gonna go ahead and admit as we keep going on. Know what your company needs. Understand your website, the platform that it runs on. Is your site a WordPress site? Did you get it from Shopify? Are you running, on one of the other e-commerce platforms? And what you add to it by way of the other vendors, the add-ons, and the apps that you add on to it. So this concept is really about, you've got your own digital real estate, right? And you're responsible for it. That's what Steve's going to talk about. Who you let in your yard, you're also responsible for, as you should be. So choose wisely. If you're spending time educating your team and doing things better, make sure everybody that you partner with digitally is also working on equitable access, so that you're not ruining the experience by putting on something that takes away the accessibility of your site.
Michele, can I piggyback on that or actually ask a direct question back to you? And if you're going to cover this later, feel free just to tell me that you're going to cover it later.
Okay.
But, right. So for our largest retailers, you all probably create or run significantly your own sites and they're a custom tool. But for a lot of the smaller and mid-sized organizations, right, there's use of third-party platforms. And Michele mentioned, for example, Shopify. And one of my frustrations as a defense-only lawyer who represents website owners and retailers is that, a couple of years ago, those widely available platforms like Shopify were not necessarily great on the accessibility front. And also, unfortunately, those contracts with, you all, our audience today, right, the website owners, operators, and retailers, those contracts from Shopify and others kind of disclaimed all liability, right? They said, we may or may not be accessible, and if you get sued for it, tough, that's on you, not on us. And so my question to you was, Michele, if you're able or willing to comment on this, on those platforms that are out there, are there some that you think are better or more helpful than others? Because I'll just say again, one thing that actually you taught me was that like Zoom for doing webinars, right, is probably the preeminent, or at least was the preeminent accessible webinar and video platform. So if you're picking between Teams and Zoom, people say Zoom is more accessible. But what about the whole website platform? Can you give us any tips there?
I can, and I'll start with Shopify because I'm going to praise them. You're right. When this first started, when we got into the business, when you started representing clients and seeing this need, and we started Accessible360, often referred to as A360 back in the day, we had a lot of challenges when we did an audit because the client could not fix everything, right? When you buy something like this digital platform, your account access, like with any software, goes, you know, so deep, and you may not be able to fix the core code. I have to say, and I've said this many times in speaking over the years, Shopify actually embraced this. They didn't understand it. None of the platforms, to your point, Steve, were really paying attention to this, but they employed a full-time accessibility expert. They actually hired Accessible360 to audit some of their new themes and that type of thing, and they have worked on it consistently. Also, through the auditing experience, when you hire an independent company like Allyant, which is now the company name of the one that I co-founded, the auditors will work together with your platform company. That's one of the great things about that digital division, is that they'll work together with the platforms, and thus so much more learning has happened. WordPress, actually, I'll give a quick shout out to them, that community, tremendous amount of market share, and their work with calling out the overlays or the gimmicks and the widgets and the plugins in the field has gone a long way to educate both platform companies and people who use them to work on their site. So the good news is that I think all platforms have been paying attention to it. Sometimes the bigger the platform organization, maybe the longer it has taken or the more intricate the changes happen. That's not surprising, I don't think, to anybody in business. But I would say it's a ray of hope. I think they're all focused on it. I think they're all working on it. And Steve, I'll put it back to you. I only have one more slide, but as we're talking about the risk mitigation and negotiating contracts, one of the things that we've consistently recommended to people is that you work on your contract language and make sure that you have that conversation in whichever path it takes, right? Understand that some of the drop and drag type website options out there offer probably the least amount of access to the core code. And so if they've fixed their core code or their theme or their template, you know, then that's great. If they haven't, then you're going to be a little bit restricted on how much you can improve the site. So I'm going to go into some trends, keeping an eye on the time, and then toss it over to you for the legalese part of our presentation today. But when asked to talk about the trends, the bad news is your business niche is still number one. You are still the number one most legally targeted by way of lawsuits and by demand letters. Lawsuits are still increasing year over year. I think 2022 showed another 10% of actual lawsuit cases, but don't focus on just the number of lawsuits that are filed. Be aware that demand letters carry with it the same angst, the same process, basically, Steve, and I know he'll talk through that. But I have estimated in the past that demand letters could be 100x or 1,000x the amount of lawsuits that are issued. You can get demand letters from multiple plaintiffs. And one thing that we talked about before joining is this: 75% of the legal action in 2023 in the first 6 months alone was targeted to companies that have annual revenues of less than 25 million. So you don't have to be a big company, you just have to have an online presence in order to get targeted. And unfortunately, you know, if you're out there, like Steve said, you're in the minority if it hasn't happened yet. So I did talk about the WordPress community doing the public service announcements. They have some wonderful things out there about the overlay fact sheet, the false advertising and overlays. We'll talk about that later after the legal section from Steve about what you can do. But if you have to leave early, stay away from the overlays. They have not yet. There's no magic wand with those. And this just requires education and work on your part. And to Steve's question, platform providers really continue to improve their efforts. So that's encouraging. So I'm going to toss it back to you, Steve, to run us through some of the legal, and I look forward to more conversations on that.
Sounds good. Let me just follow up on what Michele said with regards to the overlay tool. So I'm not going to name the most industry prominent one, but I'll say if you Google what accessibility vendor was actually banned or uninvited from the annual conference of the National Federation of the Blind, you will see, because the National Federation of the Blind thinks that their overlay tool is so unhelpful, you will see who I'm talking about. The related piece I'll say is that any so-called solution that is offered to you for $29.95 or $49.95 a month is not a total solution. Now here, Michelle and I might differ about this, and that's okay. My view is that all of these automated, there are plenty of people actually who think that those so-called overlay tools like the monthly subscription make websites worse, okay, that they actually harm accessibility. And that's Michelle's one of them, right? I am agnostic on that, all right? In part because I'm not a screen reader user and I'm not enough of a technician to have an opinion on that. I think that in some cases they can make lawsuits a little tiny bit less likely, but I also say this very clearly. I've had dozens and dozens of clients that have been using those subscription overlay tools that still got sued and still got demand letters. Okay, so when you if you Google website accessibility solution, and you'll see there are some entities that advertise, right? They'll be at the top of your Google results offering this low-cost solution. I will say this at a minimum. Number one, it will absolutely not stop you from getting sued. Does it decrease your chances? I'm not sure because the plaintiffs don't tell us. And I'll say this at a minimum. If you do choose to go that route, because I understand for a lot of small and mid-sized businesses, right, you don't have a pile of money around to solve this issue. But if you go that route, please do understand this part. It is at best only a partial solution. Okay, and so you are like things like Michelle said, like try the keyboard test, and then she'll hit later on some other self-help mechanisms. If all you do is slap up the $49.95 a month solution, you have not reduced your chance of getting sued. You've maybe made your website worse, and so you've lulled yourself into a false sense of security. So that's my little sermon on that part. And I'm frustrated because, like I say, some of those entities do hold themselves out as solving the problem. All right, I'm gonna go ahead.
I would
Michelle.
agree. The only one thing I would add that I learned, and I'm happy to share this because we're always all of us are always learning. I had some feedback from somebody with a cognitive disability in the realm of dyslexia and that type of thing. And there was one overlay that they felt did a better job with dyslexia. So, understand what it is that you're doing. But as Steve said, when you're testing with even just keyboard only navigation and you come across one of those sites with that on it, one of the biggest problems is if you're a blind person, it forces you to use it. In my introduction, I said that people with disabilities severe enough to benefit from the Americans with Disabilities Act already are going to be using their own assistive technology or they'd never get to your site. So just think through the thought process of tossing up an overlay to magically fix everything on your site. So with that, Steve, let's talk about the ADA.
Sounds good. All right. So Michelle, are you seeing the ADA slide on your screen?
Yeah.
Good.
Yep.
All right. So piggybacking more on like self-help things that a person can do. I'll stop. I'll see if Michelle touches on that later. So what you see up on your screen now is the first President George Bush signing the Americans with Disabilities Act in 1990. Part of why I put this slide up, and I'll have two slides on the actual law, is because I feel like there's a lot of chatter and a lot of secondary and even further removed sources that chat about you must do this or you can't do that without actually explaining the why. And although we're going to focus on practical tips, I do want you all to have some understanding of the why or the what's behind it. And this is where I'll say our legislature and courts have really let us down. And that is in terms of their not providing clarity. I'm going to explain why or how that evolved. And that's a meaningful part about why there's so much litigation in this realm of non-clarity. But curiously, back in 1990, right, the ADA was a bipartisan piece of legislation prohibiting discrimination against people with disabilities. Let's look at just a couple of the words, right? What does the Americans with Disabilities Act prohibit? Title 3, the portion of that for public accommodations, says that no individual shall be discriminated against, and let me circle those words, on the basis of their disability in the enjoyment of services in any place of public accommodation. And I'm going to circle the words place and public accommodation, right? So what does that mean, right? The word website's not in there anywhere. All right, so first, what is a public accommodation? Many of you might already know, right? Virtually all retail organizations are a public accommodation. Right? If you have a store or a physical presence and you are open to the public, you are almost certainly a public accommodation. Well, what does discrimination mean? The law defines discrimination as a failure to make reasonable modifications in your practices or policies available, unless doing so would fundamentally alter the nature of the goods or services that you offer. Or discrimination is also failing to include auxiliary aids or services to permit access by disabled individuals, unless doing so would fundamentally alter what you're offering or create an undue burden. All right, let me spend a moment unpacking this, right? So what basically every lawsuit and demand letter says is that there's a person who is disabled, usually blind or deaf, as Michele mentioned. So they're disabled and covered under the law. You, the defendant, are a public accommodation, usually a store, and you have discriminated because you have failed allegedly, you have failed to modify or design your website or app or digital tool. And when I say website, I really am, like Michele suggested, using it as a catch-all for digital communication technologies, that your website or app or other social media presence or digital tool has not been configured to work well with assistive technology such as screen readers. Okay, that's what this really means or has been interpreted as. And again, right, that's not, the law doesn't say that on its face, so it's not particularly clear. So the law on its face, not super clear. Also, well, I'll note two additional things, right? One is, in addition to the federal law prohibiting disability discrimination, virtually every state, including Minnesota, has a state civil rights act, so you can be sued on the state level or the federal law level. Also, some folks say, well, what if this undue burden, right? You know, I'm a small or mid-sized business. I don't have a bunch of money to go solve this. I've seen that, so that is a possible defense, and part of my job today is to talk about defenses. I have seen that defense argued and litigated, albeit almost only by larger businesses, most famously by the grocery store Winn-Dixie. And there they had what was a pretty expensive redo of their website. It was a couple $1 million website redo. And the estimates for the digital accessibility fix were $250,000 plus. And the court held that was not an undue burden. So I'll say I've not seen undue burden argued successfully. Not that you couldn't, but it hasn't been done so far. All right, well, since the law doesn't give us a whole lot of clarity, and actually, let me say one more thing about this. So for digital accessibility, let me contrast that to physical accessibility and physical ADA compliance. As many of you may already know, right, there actually are extremely detailed regulations and guidance on what you must do to create an ADA compliant physical space, right? It tells you the number of inches off the ground a sink can be, or the number of inches wide a door must be or a hallway, or the maximum incline of a ramp for a wheelchair to go up to be handicap accessible, right? So that level of detail and regulations, which exists in the physical ADA, nothing like that, unfortunately, and I'll say again, in my personal opinion, that is a failure of our government and courts. That does not exist to tell you what do you have to do to create an accessible website. And that's why people like Michele and I tell you what we think is a good approach, but courts do not and government do not give you a clear pathway to a safe space. So that simply does not exist. So that's one more part of our message today. Let's see what some court cases do say. So back in 2006, this is the first prominent case in this space. The National Federation of the Blind and an individual sued Target and said, we think there's an Americans with Disabilities Act violation relating to the website and the stores. And what the court said out on the West Coast, and I was not involved in this case, it said that if the website if there's a nexus or a connection between the website and a physical store, remember, a place of public accommodation, then the ADA applies to the website. All right. What actually the West Coast said, and now we have courts splitting and unhelpfully giving you conflicting decisions. What the California courts have said on the federal level is that if it is a website only business or online.com only business, then the ADA does not apply. Maybe state law applies, maybe something else applies, but the federal law does not. So this is a 2006, settled in 2008. So back then, I was expecting actually a wave of litigation to happen after the Target case. It did not happen. Everyone on both sides, defendants and plaintiffs, were expecting the Department of Justice to issue clarifying regulations. And we waited and waited. Department of Justice said that they were going to issue them. They said, we're still thinking, tech is changing fast, we're still thinking. They kept pushing back the deadline for a couple of years. Eventually, by the early teens, right, 2014, plus or minus, plaintiffs said, you know what, we're tired of waiting for the regulations, we're just going to start suing. And that's what happened. So that's when the litigation explosion really took off in this realm of ambiguity. If I'm going to share with you one or two other top cases in the space. So again, the Target case stood for the idea that even though the ADA applies to a place of public accommodation, a website or an app or a digital tool could be a place of public accommodation if it had a connection to a physical store or physical location. Annoyingly, there are courts in New York and on the West Coast that have taken the view that any online retailer, even if there's no physical store, the ADA still applies. And so as a result, right, for you, the practical advice or the practical takeaway for you as a business owner, if you have a website and people can view it in New York or on the East Coast as well, then the lawsuit might happen there and not on the West Coast. And so unfortunately, it does not provide like a clear pathway for business owners. The Domino's case, there was an important defense here that was tried and failed. That defense was because the Department of Justice had not given us clear guidance that it was a denial of due process. The law was so vague and ambiguous that who could even try to comply with it? The Ninth Circuit, that's the California federal court, or the West Coast federal courts, it's just one level below the Supreme Court. They said, nope, the lack of regulations does not disqualify this law. The ADA can still apply to websites. However, they did confirm that at least in the West Coast federal courts, that you needed this nexus between or connection between the website and stores. So in terms of proactive strategy, again, because there are the other circuits, other courts that can sue you even if you're online only, doesn't provide a clear strategy for everyone. But for a particular lawsuit, a particular demand letter, that if you're an online only business, that might provide a path. All right, what are some other defense wins that we have out here? First, I'll say courts are starting to notice that this is a problem. The top case I mentioned here, the Shaler case, there the court is recognizing that there is widespread abuse taking in the form of these repetitive actions. In the case of the Swarovski case, the second case I mentioned there, in that case, which was a Braille gift card case, there was a win for the defense, and the court in that particular case said that these super generic boilerplate form letter complaints and lawsuits, they don't really say anything specific about the individual plaintiff or their individual harm, that those are so vague that they do not state a viable complaint. So there's another defense win. Finally, another area of defense win was this New People's Bank back in 2018. That was in a Virginia federal court. And there, what they held is that the customer was not really a viable customer, right? It was a banking situation for a small bank, and the customer lived 300 miles away. And the court said, you're not really a real customer. And so we're not going to let you bring this lawsuit. So all of those are some wins. In a particular case, they might help you, or in a particular demand letter. The problem is that for each one of those cases and defense wins, there's another court somewhere else that probably takes a contrary position. So again, part of my view is the reason why we have all this litigation, and in most cases it's cheaper to settle or negotiate a resolution, is because our courts and Department of Justice and legislatures have let us down.
So
Bottom
Steve,
line, yeah.
Oh, go ahead. I'm sorry.
So most cases settle quickly because it's cheaper to settle than fight. And let me just hit one more slide, and then I want to give it back to you because I've taken up more time than I wanted to. What are, I'm going to say 3 things, and you all can see the slides if you want to later. So 3 tips from me. Number 1, as Michelle said earlier, vendor selection. My last slide is a sample warranty. So whether it's a custom app that you're getting, a custom website, or a platform, try to push some responsibility onto the vendor to have accessibility as an element. Next, post an accessibility statement. Okay, last 2, insurance. Check your cyber insurance policy. If you get a demand letter, they might provide coverage for you. Although candidly, most policies I've seen have a $50,000 deductible, and almost every case that I've been involved with, we could defend and resolve for less than that. Finally, don't ignore a demand letter. I know that if you see them, they might look like a scam, or they might look like if you just ignored it, it will go away. That is not the case. Last slide here is the sample warranty. That is my gift to you all. You are welcome to take this paragraph and drop it into your vendor tech professional services agreements in order to hold them responsible to develop and provide accessible tech to you. I'll take a breath now, and Michelle, let you both step in and make any comment or go with your own slides.
I think that gift is a great one. So all of you use it. We have talked for years about that. If you get hit for your website not being accessible, you start this journey, right? And you hopefully get an audit with live users, and you start fixing it, and you work towards compliance. But then as your contracts come up, that's the point where Steve and I have always recommended that you look at the contract language and make sure that you're holding everybody else that you're allowing on your digital real estate accountable for it. I wanted to go back to the Braille gift card case and just make a comment and an observation, because when this hit, I was asked a lot of questions about it. And my initial response was, a gift card, a card like this to not have Braille on it, our currency, our money in the United States doesn't even distinguish itself. Other countries around the globe have different size, different textures on their paper money. We don't even do that here in the United States. So the second comment is, well, the first observation is there's a lot of work to do there, even with just our currency here. But the second part is a lot of the gift cards are sent digitally or activated digitally. You can check your balance digitally. And so again, it just brings you back to, even if the gift card or your currency isn't accessible, when you're in a digital environment, a retail environment, purchasing goods or services online, is that experience equitable? So I don't know if anybody thought about that with the Braille gift cards, but my personal thought was, we haven't even tackled our money. So I don't know, Steve, I know you and I talked about that, but it seemed like an obvious one to me at the time. So
yeah, I think so. First, right, you make a very good point. It also taps into the idea that has not been a successful, I'll say, legal defense, but I think is a practical, like trying to be helpful, is consider an alternate method, right? So that like in the case of actually, I'll just stop there and let you go with your own slides rather than going on that rabbit hole.
And so Steve made some pretty solid recommendations. I'll take over the screen share. I'm going to move into what guidelines the industry uses for auditing. I'm going to talk about the web content accessibility guidelines, because even though, as Steve said, there is no recommendation, no formal acknowledgement of these by the DOJ or court. They did issue a statement last March, the Department of Justice did, that I think puts us on a path for 2023 being the year where I think things are going to firm up. First of all, we're now going to be hopefully issuing the third or more version of these web content accessibility guidelines, which came out about 23 years ago. WebAIM is the organization that brings them out. Your digital team should have read through them by now. You can go right to the website and read through them. And even if you don't understand all of them, you can start to see how they're set up. There's an acronym in the industry called POUR, right? Things must be perceivable, operable. They must be robust, and there's different categories that they separate things into, both for visual things, right? Like color not being the only way to convey meetings, for the 1 in 10 men and others who are colorblind don't put things like the Minnesota Wild did with their hockey sweaters, the red and green together, because people with colorblindness don't see a difference there. So be sure you understand which criteria is tested with any of the automated testing tools or scans that you do on your site. So we talked about overlays earlier. I gave my personal views on overlays. The other ways to test digital properties are automated testing and manual testing. Now, the way that the digital experts really promote best practices would be a combination of both, if you understand what limitations automated testing provide. You can go online across the internet now. There's tons of companies that offer a free scan of your website, but really do understand what it is that that's testing. Many of the clients that I've worked with over the years have either started with that or didn't see any issues with it. And so they thought their website was fully accessible. And the reason why you can't rely 100% on automated testing tools is because it's a bot, right? And humans use your website. And so I think everybody in the group probably understands there's some limitations. You may not understand all of them, but I really encourage you to learn and ask a trusted vendor, like my prior company, to help you understand that and to learn how much you can test by yourself and how much you may need by a third party and where you're at. Be sure you're doing manual or live user testing. I cannot stress that enough. That's why I issued the challenge to all of you to try and purchase something on your website without using your mouse. Currently, my recommendation is to strive for level AA of the WCAG version 2.1, and here's why. 2.0 is quite dated. There weren't that many changes to 2.1. Everything is retroactively. What happened with 2.0 and 2.1 was this. As a vendor in the space, I saw this happen. When the new standards were issued, and again, they're not vastly different. I heard a lot of people say, and a lot of the defense, that we saw back years ago was, oh, it's so crazy, and there's it's all over the board, and you don't know, which one to follow. It's not that complicated. There is an understood best practices, which is the WCAG version 2.0 to 2.1. Wasn't that grand of a difference. You could learn 2.0 and add 2.1 issues. The new 2.2, which we should see out this year, only has 9 additional things. One issue changed from a level AA down to A, and I will talk about levels as well. So drop that talk track. It's not, this is the standard. It's used internationally. There isn't another one. There are some additional ones that we came across in my practice over the years, but there's nothing that's going to replace this, in my opinion.
Michele, can I just jump in for a second?
Yeah.
So I'll agree with everything Michele is saying. And right, again, you can just Google web content accessibility guidelines and you can find them and see them for yourself, right? And if your technical team's asking you questions, you can point them to that. On the scanning tools, let me just give a concrete specific tip, which is there's a number of them out there. I think they all have limitations, but I'll just say the one that I use as my go-to is called Wave, W-A-V-E. And so I will say, right, if you're just starting out, go and try Wave and run it on your own website. Again, it's free. It will tell you how many so-called errors you have. I think that plaintiffs use this tool. So I'm going to give you my based on experience goal, which is if you have a so-called error score above 10, and especially if it's more than 20 or 30, you are at meaningful risk, like you will stand out to plaintiffs. Conversely, if you have a so-called error score between 0 and 5, I think that many plaintiffs might tend to leave you alone. Now, this wave score thing is not the law. This is like a total shorthand shortcut, but it can be a useful partial guide for your own activity.
I agree that the Wave tool is a great place to start. As Steve said, it's free. It's been around forever. It's got a pretty easy interface. However, I do not personally think that when we're speaking about the majority of the plaintiff firms out there, I'm not sure that they even run a scan on your website before they send you a demand letter. In my personal experience, I think they send them out en masse. And there's so much that's missed by all scanning tools, including Wave. In fact, Wave actual terms and conditions of use strictly prohibit it from being used to determine if a website is accessible or not. So it is a great place to start. If you haven't done anything, use it. It's free. There's other ones out there, but understand that it's only the beginning of your journey. You have to get a live user audit. If you don't have the members on your team, which most organizations don't, that are qualified to manually test, then work with a vendor. And as I said, you've got a great one that was started here in Minnesota, so give them a call and get some help. They'll help you and your platform work through the changes that are coming in 2.2 as well. Some other tactical things I will say is build this into your process. This whole topic is not an event. It is a new way of designing and developing in the technical world. It's not a fad, it's not a phase, it's not going to go away. Stop and think about why it's not going to go away. Humans are not going to go away. People with disabilities, and at the rate of 10,000 baby boomers turning 65 every single day, more and more and more of your clients and customers are going to develop disabilities. You will likely develop a disability, hopefully, because you'll have lived long enough to have your eyesight go or any of these things. And so this universal design, this inclusive design and development practices, it helps everyone. Don't think of it as, I would challenge you, please don't think of it as just a legal thing. Think of it as this is about humans. And just like in everything that we do, we're trying to be more inclusive, and we're looking for other points of view. Don't leave these people out. They have a tremendous amount of discretionary income, and you're just putting your head in the sand if you ignore this as part of your ongoing builds, website edits, get your marketing team involved and everything. So what I encourage you to do is to think about your overall plan and plan in your budgets to offer equity. And that means get funding for this. When these lawsuits first started, nobody had a budget line item for digital accessibility. And I'm happy to say over the past few years, I've seen, previous clients reach out and other people reach out and say, how much should I put in my budget for next year? That's a great first step. If nothing in corporate America happens by accident, right? Very few good things happen by accident. So get funding for this into your budget, test during your builds, right? Get all of your departments on board. It's not just your agency if you use one. It's not just your platform provider. It's who's ever making changes. It's the content marketers. It's everybody who touches any digital product of yours. Get them on board, commit to being inclusive, and also verify your outcomes. So don't do this once a year. Do it as part of your whole digital plan and make sure that you're focusing and doing everything that you can with your digital properties in order to make sure that they're offering equitable access. So a couple of key takeaways, again, choose carefully. Steve and I have kind of hit this one pretty hard in today's talk. When you're working with a platform provider, ask the questions. That's the time when you're in negotiation. Use the contract part that Steve gave you. Hold them accountable. Ask them which themes have been tested, and how to use the templates within that theme, right? And by this, I mean, everyone knows when you go to add an internal page on a website, your developers don't start with a blank white screen, right? They're going to pull in a template. So make sure as you're adding promotions and internal pages that you're using templates that you've already tested, then you're going to be in much better shape. Plugins and apps on the site. I've done a lot of speaking in the past with Shopify. They're one, as are a lot of other platform providers, that will tell you it's an open market. Those marketplaces on e-commerce platform sites where they have all these apps, especially the apps for accessibility, they do not endorse, Shopify does not endorse those. It's a free marketplace. So buyer beware. Steve, I invite any comments that you have on that. But again, when we started the talk today, I talked about your digital real estate. Make sure anybody that comes into your yard is also paying attention to this. Post an accessibility statement, as Steve said, and I'm going to give you an additional little tip here. when you go to your website and you load your website, hit tab to go through your keyboard only navigation, the first thing that should come up per the WCAG guidelines and best practices is a skip to main content. That will allow somebody using screen reader technology not to have to listen to everything in that top navigation bar and get down into the body of it. You can imagine how tiresome and laborious that is to listen to all of that. So help screen reader users and others who rely on keyboard navigation to skip through. The big tip here is, I think, my personal opinion, the second thing that you should add is a skip to your accessibility statement. And here's why. If many of you say, oh, great, we have an accessibility statement, it's in our footer, it's down here, understand the user experience of that. If you don't skip to it right away, no one's going to hear, if they're blind, that A, you have one, until they navigate all the way through to it or search for it by name. But also, in the instance that you get a demand letter or a lawsuit filed on you, and you have implemented this practice of having the skip to main content and then putting in a skip to the accessibility statement, which should read, and we can discuss this, Steve, a little bit, you know, you're committed to offering equitable access. If you're having any trouble purchasing on the website, please call us or email us here. There's two different alternatives. If you don't have a telephone number, then offer the email, put the email into the same customer service email that everything goes into. One horror story I had over the years was somebody created a new one for accessibility issues, and then the person who did it left and they never checked it. So put everybody in the same pool, everybody together, put them in customer service. If you then get a demand letter or a lawsuit from somebody who says they're blind and they had trouble on your website, you can say, the second thing that comes up on our website when using screen reader technology, as you've indicated your client, Mr. Plaintiff Attorney, is dependent on, is a skip to the accessibility statement. We don't have any record of them asking for help. Did they experience that? So I'll open that up for conversation, Steve. And then just to round out the left side of this slide here, heading levels, alt text, closed captioning, and transcripts. You may not be able to do everything all at once, but start with these basics and get some of these fundamental things in. I think are we running over, or how are we with time?
We're I think at 10 o'clock.
Yep. So mobile apps and marketing, don't forget these things. I have a couple more slides. I'll put them up here. And then I just want to talk about some Q&A and anything else that we might be able to help you with. Again, test regularly, document the tests that you've done, get an independent audit done. Don't forget about documents on the website, any PDFs or anything like this. There is no magic wand. Right, Steve?
Agree, right on. I see that there's a question from someone in the chat about in-store tools, and I'll just note there that that's also a source of litigation and accessibility. Actually, the plaintiffs who started the website lawsuits, before they did those, and the reason why actually I got involved is because the same plaintiff attorneys were suing banks for not having Braille and disability-friendly ATMs. And so, yes, in-store kiosks and point-of-sale items is part of the whole package, but that'll have to be any further detail will require another conversation. Maybe we can talk to Bruce about doing something in a few months.
I think that would be good.
I'll just say that thank you so much. Our emails are up there, both Michelle's and mine. And if we didn't get your question, you could reach out to either of us. Bruce, thank you so much.
Yeah, thank you guys. Steve, Michelle, thanks a ton. I just want to do a couple thank yous. And then I think what we'll do is maybe we'll turn the recording off and see if you guys can linger around. Maybe there's a few more questions too. But we can do that post-recording. So I just want to thank again, Steve, Michelle. I forgot to mention you were gracious enough in 2016 to cover this topic for us. Thanks for coming back in 2023. We really appreciate that practical advice. Thanks to all of our chamber friends who are on today, including those from the Monticello Chamber of Commerce and Industry and the Elk River Area Chamber and the Delano Area Chamber, Fergus Falls and Little Falls as well. Thanks for joining us. We always appreciate your participation here. And we'll make this recording available to everyone so you can come back and peep through. I think somebody had a question about slides too, so we'll make sure materials are available to you as is comfortable to our presenters. So Steve, Michelle, thanks very much. I'm going to turn off the recording now and we'll go to some other live questions. But thanks for joining us today, and everyone's welcome to hang around.